So I feel like a good place to start is what does family court, like what kind of cases do they cover?
Everything except divorce as it relates to the family. If you have an intimate romantic relationship with someone or a blood relation, you are allowed to go to family court.
Okay, and what does everything mean?
It could mean so many different things like custody, visitation, child support, spousal support, orders of protection, juvenile, if you get charged with abuse or neglect. There are juvenile proceedings in family court, and there's many other areas as well.
Okay, and so how does a family court case start? Like, what is the process?
Yes, so if it's started by an individual, meaning it's not like ACS or another agency starting a case, it always starts with a petition. And by the way, for the audience, all of these petitions are online. So if you were to search, family court custody petition and maybe put PDF or DOC at the end of the search, it will actually bring you to all the forms. Everything starts with a petition.
I got a question.
Yeah.
One of the things you said, I think, is a little bit more ambiguous. We can fix that up, right?
Yeah.
A little bit more.
Say it again.
One of the things you said was a little more ambiguous than the others. It was intimate relationship.
Yeah.
And giving my criminal background, that's something that qualifies for domestic violence cases, which sends criminal matters to a certain part. The IDF is also part of that, which is the...
I think you mean the IDV.
IDV, I'm dyslexic, so I switched it around. But so the significant intimate parts. If I have a kiss, if me and a girl kiss, right, does that make us intimate relationship? Can then she go to family court and set a petition against me, or does it have to be more, or is it subject to just jurisdiction, or?
Very, very interesting question, because it's a legal term of art, right? That is a legal question. So if you were in doubt, I would tell people to go ahead and file. I think it has to be a little more than just like maybe one date or you saw them one time, but certainly if someone is stalking you and you started off potentially as a romantic relationship, you might have grounds to do it. And the family court, it's fact dependent because, like I said, it's a question of law, but you could try to argue that as jurisdiction, but I would say it is probably not the highest standard. So if there's any sort of romance involved, maybe even a couple of dates, I think it could suffice.
What if it's like one date, but you have sex? Like what? Like I'm trying to figure out, is there?
Then
And I guess the answer
probably,
is no.
that'd probably be the.
That's a harder sell than just
yeah.
like. And what if it's 10 dates, but there's never been any like physical intimacy besides meeting up and courting somebody?
I wonder why there was 10 dates.
I mean, that's for them to figure out.
Yeah, right.
I mean, so does that almost like a standing type situation? Does that part, whether it's intimate or not, get litigated a lot in family court?
Yeah, I mean, I tried it once in a relationship. I said, Your Honor, this is more like a civil issue, like a harassment, maybe defamation. I had the respondent as a client. And so I tried to argue it, but the judges are very loath about relinquishing jurisdiction and power in these cases. They hold them very near to the court. So that one we settled it, we resolved it, but it didn't seem like my argument was actually going that far.
Okay.
And coincidentally, it's actually very interesting that nowadays some people think they can file a family offense petition if they've had sex maybe 5, 6, even 7 years prior and have had no contact. But there is now substantial case law, right?
Good point.
Right. So there's substantial case law now in the family court that says that that's not an intimate relationship.
Yeah.
It's not going to be enough. So there is a time factor that needs to be considered. So I'm not sure about the circumstances in your case, but if the time factor is a month, that's probably going to count for family court. If the time factor is a couple of years and there's been no contact, we have a different issue.
Okay. So going back to the process, it starts a petition. I've been tangentially involved in some family court cases, and I know the hardest part is that you have to serve these peoples with this petition, correct? Well, what's the process? You get your case number?
Yeah. So you file the petition, and you can either do it in person at the petition window, or you can do it online via EDDS. It's called Electronics Document Delivery System. It is the family court's filing system. It's not as robust as the Supreme. You can't retrieve as much, but you can send it online. And then you are issued a summons, which will contain a file number and a docket number. And you take that, and you are supposed to serve it. They give you instructions, actually, on how you're supposed to serve it. If you want to keep it professional, spend $110 on a professional process server. It's worth it. Then there's no question if you got your cousin or a friend to do it. So if you want to do it professional, get somebody to do it. But yeah, you have to serve it personally. You can't do it on Sundays, and around holidays is questionable. But yeah, you must do, generally speaking, in-hand service.
Sorry, I have a service question. What about like if I have a doorman or somebody that takes packages generally for me? Would that be acceptable service, or does it really have to be in my hands?
So that would be what's called substituted service. Generally, with divorce and family court actions, the standard seems to be a little higher when it comes, if they want to question service, right? So I would ideally try to get it in hand, but there are other ways to get substituted service, such as like you drop it off with the mailman, and then maybe you mail it, but the gold standard is in hand.
In the hand.
And it's like, this is like giving me back the heebie-jeebies of civil procedure law.
Yeah.
But it's like, you theoretically can leave it on their door, right? Is there like a way you could do that? And then like, what I've always found weird about service is that they're gonna come to court and say, I wasn't put on notice of this case that I'm currently in the courtroom for.
Right.
And if I get you to agree, I'm gonna leave. You're gonna have to catch me if you can, basically.
And you can't service somebody in court, correct?
No, it's considered a little gotcha.
Yeah.
To do
So
that.
because they don't want. I think my understanding, because I just starting to get into the family law world a little bit. They view it as they don't want to discourage people to come to court. So if you know you can come to court and the other party is going to be there, what are the extent? I don't know if this is bleeding into, but what are the extents of that? Like, what about the court? Like in some of these jurisdictions outside New York City, they have parking lots and shit like that.
Yeah.
Is that okay if I say that word?
Yeah.
Stuff like that.
If you accept this, we do.
What are the limitations for? Is it on that court day? Or I don't know if this is a litigated issue or not. Like service for you can't service somebody inside the courthouse, right? Because they don't want to discourage people. Or you follow them home or something like that. And I mean, or does it have to be a separate interaction that's separate from going to court?
I would say maybe not quite as they're coming in, but maybe after it's over. That I think could be fair game. Judges routinely will grant like a hearing though to determine whether service of proper, just basically upon the respondent saying I didn't receive it right, or is it left with a child, or whatever it is. Yeah. They'll say, you know what, let's get to the bottom, because it is a jurisdictional question that could nullify everything.
Yeah. And then you just have to resurface, right? It doesn't stop. It just means you have to restart. Correct. It doesn't prevent that person from being served.
You already got the temporary order of protection, right? So, and that can actually be served by the sheriff.
Yes.
But yeah, all they would do it is just adjourn it, leave everything in place, and then say, come back and prove that you actually did proper service.
So the nice thing about the sheriff's office is they don't charge you for the orders of protection from the family court, but you can also pay them $52, really low amount, to serve pretty much anything in family court: custody petition, visitation, child support. And the thing about it is the court trusts them, and they're allowed to serve through substituted means because they're an agency and they have an executive authority that allows them to access records and get things to you in different ways. Sometimes they serve via text message.
No. So instead of hiring a process server for $120, you can use the sheriff's office for $55.
Yeah.
There have to
Sounds
be
like a cheat code to me.
big government coming in to snatch a little. But is there requirements for having the sheriff do it? Does there have to be some sort of, order of protections are backed by criminal penalties,
Yeah.
right?
Yeah.
Is it something like, or is it just like, no, they're just the state?
So the only ones that are free are the orders of protection.
Yeah.
Okay.
Yeah.
But
Everything
the other
else would
ones
be-
you pay them. You're
Yeah.
paying them
Okay.
to do a service.
Yeah.
Okay.
And when they show up, it looks just a little stronger than like a regular.
I would
It's just
fuck
weird
that.
the idea that law enforcement
Yeah.
can act in a civil
Yeah.
capacity.
Yeah, like
Just
a profit
brings off a
making,
little,
right.
just a little
In New York,
problematic.
in New York City, the sheriffs often work on civil matters. Housing court, small claims
Evictions.
matters,
Seven,
right?
yeah.
They serve the evictions, they serve notice of eviction,
943s.
right? There we go. And additionally, we know that the sheriffs are frequently used to do civil commitment orders and civil seizures of property or people. So these are constantly done.
Yeah.
Okay, so get a petition, assuming you served it correctly. What's next?
So get the petition now. Actually, you don't yet have to get it notarized because they changed the law. CPLR 2106. You can just affirm that, and that it'll be filed. So you can do it like in the privacy of your own home. Send it in. It's better to go in person, especially if you're seeking an order of protection, because nothing replaces that, FaceTime.